I, I graduated law school in 2002, and one of the first cases that I was on was the Vioxx Arcoxia COX-2 inhibitor litigation. So this is worldwide. This is when Merck was sued. And early e-discovery was just that. It was boxes of discs. So when we would make a production, we would have all these CDs and DVDs with tens of thousands and millions of documents on them. And all of those were initially reviewed manually with teams of contract attorneys in New York. From there, I moved on to litigation involving General Motors, some old asbestos liability litigation, and started white-collar criminal defense practice as well. And lately, most of my practice has been centered, as far as volume and e-discovery, on data breach litigation. So those compromises of databases and intruders on systems. Not only is it similar volumes of documents, which really have continued to increase as time's gone on, but newer technologies. And I'll preview what I'm going to talk about this afternoon. And I think a truly unique opportunity for all of you. And for India generally, if you want to find what the next steps are, where there are opportunities that are coming up that are not yet addressed in the United States and may not have the right level of opportunity within the United States to address them, those are places where there is going to be a need.
Excellent, thank you. So James and I were the same year out of law school, and so I too started where in the very beginning they would literally print out emails, put them in a banker's box. You would stack it sideways and go through and mark the coding. So you can. That was probably still the fish before you're on your graph. And then I continued on at a law firm. And where I really got involved in e-discovery was on a matter where I was representing an entity, very sophisticated internal legal department, but they had never issued a legal hold or conducted any e-discovery. And this was well after the case that you had referenced, the gender discrimination case called Zubalake out of the Southern District of New York. And so contemporaneously with developing their, representing them in this internal investigation, I built their program from scratch. And I really enjoyed that aspect of e-discovery and developing the processes from what you would want it from, not just a reactionary view, but a playbook going forward. And then from there, I joined a company that had actually one of the most significant sanctions in America at the time due to a failure of e-discovery. And so they really had it top of the mind and wanted to build a best-in-class practice and brought me in for that. And I left soon thereafter because I wanted the next challenge of it, and we'll discuss this a little bit later, some of the cross-border complications that develop with e-discovery as well.
Good. So I think it's easier. So the issue of preservation, I brought it up, and I think it's important because it may not be well understood in India how significant it is at the very start of litigation for lawyers to send a letter or to somehow notify the other side to preserve electronic evidence. And so can we talk about your experience with sending out or receiving litigation hold letters and what issues may have arisen with preserving ESI?
Yes, we certainly can. So when talking about legal holds, it's this idea you're signaling to the other side, or you understand that you have an obligation to hold on to that information that may be or is likely relevant in the litigation itself. And I heard it best summed up, it was actually in New York some number of years ago by a judge. The judge said, you know what, I'm a lawyer. I may not be the best at math, but I can do basic math, and I can look at dates. And this is one of those things when I work with associates, I encourage them, if you've got 5 tasks on your desk, and one of those is you have to schedule a meeting with someone, what should you tackle first? You get that meeting down, because things change really, really quickly. Schedules change, people are unavailable, and if you don't take advantage of that, it's going to go away. Well, that's a legal hold. The information we're dealing with is ephemeral. A lot of it goes away, a lot of it's not held in a proper way, it's not governed. And if we don't get our arms wrapped around that initially, if that information goes away, it is gone, and then we have to deal with the consequences.
So I would just like to pick up on two challenges from that aspect. And challenge number one is when the day one when you want to implement the legal hold, you may have just received the complaint. You can be in-house and extremely knowledgeable about your company, your people, your business, but you still might not know who the players were. You might not know which engineer was working on that emissions device. You might not know who you have to place on hold, and that takes time, and that time is critical. So that's one challenge that I'd like to raise in the preservation aspect and the legal hold aspect of it. We've got lawyers and non-lawyers up here. We've got a lot of law students, and when you're sending out a legal hold, it can be a little daunting for your custodians who may have never received a legal hold before and may have no idea what this language is. And there's a tension from the lawyers that want to talk about, well, you have to preserve this sort of data, that sort of data, any and all, and these sort of phrases that get folks nervous. And it's coming from the legal department. Maybe they haven't had many interactions from the legal department. And I think folks fail or tend to forget that when legal comes knocking on the door of the lines of business, that can make people really nervous, and that impacts how they actually implement that legal hold. And that's how a company is going to manage their preservation, is the folks on the ground and what they're doing who can touch and access the data.
Here's what I'm going to do. Because of time, I'm going to turn it over to for questions and answers to Capstone Legal to moderate. But I'm going to ask a question, one question or two questions of the lawyers here, and then I want everybody on the panel to think about exporting U.S. e-discovery, whether that's a good or a bad thing. We have a conversation in the room about that. But the one thing I want to talk about smartphones, because I read a book this week flying from the United States about how smartphones are exploding in India in terms of the number of people that have access to the internet. And in some way, it's leapfrogged other technologies. Not everybody has a computer, but lots of people have smartphones. And can you, James, talk a little bit about the issues about e-discovery on devices? You mentioned bring your own device policy if you want, but how do we U.S. lawyers think about what do we think about when we think about getting evidence from devices like smartphones? It just may be unusual or something novel in India to think about e-discovery and smartphones, but I thought it would be a good question to ask for just the panel.
I mean, it's a concern, and at the end of the day, what I'm concerned about as a practitioner and what I have to deal with e-discovery is, where is the information? Where does it reside? And it is in large part custodial driven, although that's changing a bit too, as information is automatically generated by a lot of processes and a lot of technologies. The idea that you can carry around a supercomputer, as it would have been phrased 15 years ago, in your pocket now, and all the information that generates, that's a real issue for us. And lawyers are perhaps not the quickest to adapt or adopt new technologies and adapt the practice to them. So we've got a little bit of a translation problem when dealing with our clients and people who would have information on those phones. We still have to get it if it's relevant. We still have to preserve it if it's under the legal hold. How do we make sure that we've considered everything we need to? And I'm sure this is something Taylor can speak to, about how you ask custodians how they use those devices, but then you have to go through and really pick apart and say, hey, this is how this device can be used. Are you aware of this or not? You have to fill in those gaps. You have to educate your custodians so that you can have a real conversation and get real information, rather than a lot of, well, I think this happened, I think this is how it works, where at the end of the day, no one has any absolutes and you haven't done your job.
I mean, I would just pick up that the amount of data that is in smartphones is unbelievable and will just become more and more important for litigation. But, we're going to talk a lot about AI and technology, but at the end of the day, it's people. It's a person's smartphone. So the lawyer, the in-house counsel, has to go to the custodian and have that conversation about, Jason, I need to take your smartphone and I need to do a forensic image of it, and it's going to collect everything. It's going to collect, the pictures of your kids and, the text with your wife and that sort of thing. And having these conversations, so we're going to talk a lot about technology, and that's extremely important when we're talking about the future of the law. Well, we can't lose sight of the fact that it's human-to-human interaction to actually implement so many aspects of this.
And don't forget, the technology can lie. Don't forget that. So there was a company in the United States that gave their employees Fitbits. And the idea was, if you were familiar with the Fitbit, it's like an activity tracking device. It'll see how many calories you burn during the day. And if you burned a certain amount of calories, then you'd get help on your health insurance. So you actually pay less. And they looked at one woman and her activity. She would get home from work and she would have a lot of activity in the hour after she got back. And it turned out she was putting it on her dog. And the dog would run around in circles. You have to be careful with what types of, really what you're pulling off of that data. You have to think intelligently about it, and that's the next step, I think. We can't just trust the technology blindly. We have to find the story behind it.
Okay, her time is going. I want to ask Doug, I'll give the microphone to him, what should law students in particular, but from this morning session, what would you want them to know about what's good about U.S.-style e-discovery, and maybe what concerns or issues you'd have about exporting it to the world? We'll start with Doug and we'll go down the line.
So one thing that U.S. politicians have mastered is whatever the question is, they'll answer the question they wish had been asked. So let me turn the question a little bit, because I was intrigued by this issue of exporting U.S. e-discovery practice. That does not seem to me to be the right thing to do. What seems to me to be the right thing to do is to share ideas. And one of the ideas is that we have in the U.S. A well-developed technology sector and a well-developed legal sector. And until these two worked together, this e-discovery problem was intractable. You have in India a well-developed legal sector and a well-developed technology sector. And you should think about how in your legal system there are cases in which people like Jyothi and me could potentially be helpful. And you can see the effect it can have on us. It's in our interest to work on these kinds of new problems. I'm here in India for this, and then next week for the annual conference of information retrieval researchers in India. And we have in the past at that conference had contact between the law and the information retrieval researchers, but not on the question of e-discovery, which isn't structured in the same way here as I understand it, but rather on the task of analyzing the law, of making logical representations of the law that would then allow expert systems to be built that could help people to interpret the law and to apply the law. And so this is one example of a way in which lawyers and technologists can work together. And I think that's the example that's worth learning.
So I think instead of exporting the same exact procedure in US that e-discovery US follows, I think in India, with a bunch of smart people here, you could actually find something to start with. I wouldn't say that, I understand the Indian legal system is way different from what actually the US legal system is. So, even if you can actually find one niche where you can actually apply, for example, there's a lot of Internet of Things happening. What about duplication in Aadhaar card? I don't know if that is going to be a problem. What is everyone having an Aadhaar card in India? Or what if can an NRI have an Aadhaar card in India? I don't know. Because each time I come to India, my dad says, why don't you apply for Aadhaar card? You have an NRI account and you may as well, you actually have a PAN card. you have all these things, so apply for Aadhaar card. So one thing I don't know is, me living in United States for the past 10 years, I have a PR from in United States, can I actually have an Aadhaar card, right? So there are some legal things around that as well, and maybe it's not a litigation, but even finding out information for common good, for maybe there is e-discovery or something, legal things for common good, for social man, to approach it, to give people an idea as to where to go. My parents are quite old, and if there is any kind of legal things, there is no way they can see where to go. If you can index those documents, there's a lot of AI work there. There is a lot of public data available on the internet. And if there is a system where people can go and search for things and find things, that is still, you are using AI in the legal setting for people to go and get the information with the Internet of Things happening here in Modi's administration. So I think it's not the same thing. It may not hold for litigation because the court system here and the court system in United States is way different. But actually, if you youngsters can find that particular problem and you can actually take it up and solve it with a good group, I think it is still a good place to start. And India is actually ready with the amount of talent we have for any kind of using AI in the legal setting.
So I think there's a real opportunity to leapfrog here and pick and choose the best of the system. And with leapfrog, I'll talk about the New York subway system. In the 1889, it was amazing. Now ride it and you will not be pleased. But I remember in 2002, I went to Taiwan, Taipei for the first time, and was amazed by how nice their subway was. And I think there's an opportunity here to leapfrog and just take the best from it. And what do I think is the best from the U.S. discovery perspective? The ideal of it, in that we are searching for evidence to get to the truth so that disputes are decided on the merits. That is great. That is the benefit. That is the ideal we should be working for. What is the downside? The cost. It has been abused in order to essentially inflict pain on the other side, so that there is a war of attrition and litigants will settle rather than getting to the merits of the case. And so I think that's the real downside.
Yeah, everyone said what I was going to say. So do better. I mean, that's what it is. Take the knowledge that's already been accumulated. Please, for goodness sake, take the decade and a half that Taylor and I have devoted to this practice and start there. To Jason's point, you're already leapfrogging ahead to, you don't have to build the copper wire infrastructure to build a telephone to every home. You've got the mobile networks, you're already there, you're moving toward that next part. You don't have to go through the growing pains of a lot of the initial AI and very, very basic machine learning applied to e-discovery practices. You can stand on the shoulders of those giants and become giants yourselves. There's a hunger and an application here to do better and to show what can happen next at a price point, to Taylor's point, that makes sense for U.S. organizations. There are places here, we'll talk this afternoon about what some of those new opportunities are. So you can see further afield and you can say this is coming even if the attorneys haven't grasped it yet, because this opportunity hasn't become so visible, so available, but you can see it coming. You have a chance to become expert and then intersect when the need is there. And it's an amazing time.
I'll reserve my remarks to the afternoon, but I want everyone in the room to please acknowledge the panelists here and thank them for their participation today, this morning.